Does it work?
Hello, ladies and gentlemen. I'm James Hardin. I'm a member of the AAT, Americans Against Tyranny. And we're here tonight to talk about some personal traffic experiences and to give you folks some motions and stuff that you can use and show you ways to set up your own legal briefs, to file in the courts, to beat these road Nazis. So anyway, I'm right now in the middle of a court case, and I've sent off to the Secretary of State, which I suggest everyone does right off the bat, and you send off for their statement of elected officer, which is that applies to the judges, and the oath of office also applies to judges, and it also applies to the district attorneys. And an anti-bribery statement. In the state of Texas, all officers have to have an anti-bribery statement on file where they took an oath swearing that they didn't accept any bribes to obtain that position, and swearing they will not take any bribes to continue to hold that position. And also, I asked for registration of foreign propagandists and foreign agent registration statements. That has a lot to do with the Bar Association. Personally, I've been before the judges and arguing with them, and the DA will be over here, yak, 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 and I'll just keep saying, I object. I haven't even seen his foreign agent registration statement, and as per Rabinowitz versus Kennedy, foreign agent registration, 1938, he is required by law to have a foreign agent registration statement on file. The reason is this: anybody who is a representative or such things, such as a representative, accountant, anything like that, for a foreign principal or power, must be registered under this act, the Foreign Agent Registration Act. And my argument is just simply that I haven't seen this guy's foreign agent registration statement. The judge looks at me and goes, well, he's the prosecuting attorney for the city or for the state. And I say, I object. He has no part of our local, state, or federal government. He's a dues-paying, card-carrying member to a private club. And his oath and his duties and his best will and interest is to that club and not to the city or the state or the citizens thereof. So you want to have this. This one that I sent off for personally for Judge Reagan Helm of the County Criminal Court Number 1 of Harris County, Texas, and Officers R.T. Hatcher and M.W. Sally of Houston Police Department, Harris County, and attorneys Michelle Bennett, Shay Taylor, and Robert Summerlin. Robert Summerlin is the one that I had a personal run-in with at the courthouse Number 1 of the County Criminal Courthouse. And Mike Hawkins, I don't know if any of you guys know him, but he's a friend of ours and another member of the AAT, and he went with me that day to court. And I filed a motion that day for a notice of motion. Anytime you file a motion, you need to have a notice of motion to your city attorney office, and then, which pretty much looks like this. I don't know if you guys can see that. And then you want a notice of motion for what you're asking for in your motion that goes to the courts also. And then anytime you file a motion with the courts, you need to have 4 copies. One for yourself that you get file stamped, because I've filed cases this thick and the DA's office lost them, and so did the judge. Never seen this. What do you mean, motions? You filed motions? Absolutely. Why is it that I'm the only one with a file stamped copy? How can you lose it and the DA's office lose it? That falls under RICO statutes. But at any rate, I filed a motion for dismissal for lack of jurisdiction, and it doesn't matter what kind of case you're in, if it's traffic, if it's family court, if it's civil, administrative, legislative, it doesn't matter. You always want to file a motion for dismissal if you are the defendant, that is, for lack of jurisdiction. And, first reasons are what we've already went through as far as foreign agent registration statements and so forth. The other one is, another reason would be, I believe in the Texas Constitution, it's Article 2, Section 1, for separation of powers doctrine. They're in violation of that. They've created legislation, and through this legislation, they have created administrative courts and proceedings, and then they also have judicial proceedings. And so the first question you want to ask up there is this an administrative hearing or is this a judicial hearing? I demand a judicial hearing. Never accept an administrative procedure. When you are the defendant, you want a judicial proceeding in there. And the reason why is because if it's administrative, they're not bound to anything. They're not bound to the Constitution, and they can hold you liable for all these statutes and stuff that are in contradistinction to your constitutional rights. And so what I said on this one is James D. Hardin, by restricted appearance under Rule E8 of the Supplemental Rules for Certain Admiralty and Maritime Claims, hereby invokes the common law jurisdiction. You must invoke the common law jurisdiction always, right off the bat, of this court by virtue of Article 1, Section 10. And Article 1, Section 10 of your Texas Constitution states that any defendant in any criminal proceeding has the rights to defend himself or by counsel or by both. And as Mike saw in my case, they tried to take me out in the hallway, and talk to me about it. And I said, hey, I know where they're going with this, They're trying to create a little mock trial deal here. So when they asked me to come out to the hallway, I want you to come with me. And when they ask you who you are, you tell them you're a friend, a witness, and counsel. And so, sure enough, we all go out into the hallway there, and at the county criminal courthouse, court number 1. And this Robert Summerlin guy, they sicked him on me because, first of all, to back up a little bit, I filed these motions. The judge is up there reading through them, and he's like looking around, he's reading some more, and he looks around, and then he has this woman come up here and says, hey, the judge wants to speak with you. So I went up there, and he goes, who wrote these motions? And I said, I did. And he goes, well, how do you know all this, and where'd you get it from? And I said, well, I've been studying law for about 5 years now, and I did it myself. And he goes, well, what kind of law? And I said, constitutional law and American jurisprudence. And American jurisprudence is in line with the Constitution at all times. And if you look up the definition to am jur, it says it's the conscience of the law. And so what I did in these motions, and there's copies available for everyone if you want to get a copy and go through them as we go, is they're already in their appealable form. And what I mean by that is when you go out and the judge says, I'm dismissing this is a frivolous motion. And then, of course, your first response to that would be, okay, sir, if it's frivolous, of course, you're prepared to tell me by what grounds is it frivolous. And force him to tell you right then. Too many people go into the courts and the judge says, I'm dismissing this is a frivolous motion. And they go, oh, okay. And they walk out a loser, Make the judge tell you, by what grounds is it frivolous? And I hereby request opportunity to correct that frivolous portion that you say you're dismissing it for. And tell them that you are demanding the right for that opportunity to amend it and to correct anything that might be frivolous in it. And so this woman comes up to me and says, you Mr. Hardin? I said, yes, I am. She goes, well, I'm looking here at your case, and I show you served 2 days in jail, and the fine for driving on a suspended driver's license is 3 days in jail and a $100 fine. So you served 2. If you're willing to serve 1 more day and pay us $100, then we'll just dismiss this. I let that her. I said, how about no, and how about we go to trial? And she immediately picks up the phone, and then the judge picks up the phone, and then she hangs up, the judge hangs up, and he picks up the phone again, and he keeps on reading through my motion, and you see him da-da-da-da, and he hangs it up, and about a couple minutes later, you see him steadily looking up like he's looking for somebody. And finally, I guess the person he was waiting on arrived. They called in the big dogs for me, and decided that I was about to chew that average prosecutor up there, and that they better get somebody else who carried a bigger load, So they sent the chief prosecutor for criminal court number 1, Robert Summerlin, and he came in, and that's when he asked me, am I James Hardin? I said yes, and he tried to take me out in the hallway, and Mike Hawkins is with me. He's like 6'5", 6'6", and probably weighs about 300 pounds, and big old beard, and he's just a huge guy, So we're standing out in the hallway, and Mike's standing like right here, and I'm standing right here, and this Robert Summerlin, DA, is standing here, and he's trying to talk to me, and he can't help but notice this huge figure right here, So he looks at him and goes, who are you? And he goes, friend, witness, counsel. And first words out of his mouth, well, are you a member of the bar? He goes, I would never. And so he goes, well, if you're not a member of the bar, then you can go to jail trying to be his counsel. And he goes, whatever, man, but I'm not a member of the bar, and I'm his counsel and a witness here today. And that guy goes, no, you need to leave. You get out of here right now. Mike goes, no, I think I'll just stay here. And Mike's looking down at this guy, and this guy's looking up at Mike like this, and he says, you need to leave right now or I'll have you arrested. And Mike looks around and goes, for what? Standing in a public corridor? So after that, the guy just starts twitching like this, And he goes, come with me. And he gets totally irate and starts going back down the hallway to go back around into the main entrance of the courtroom. And he's twitching like this, and we get up to the bar point, which is the section that separates the folks that look on to the proceedings from the members of the bar and the defendants and plaintiffs and judges and bailiffs and so forth. And we get right there, and he turns around and he goes, you stay here, and you come with me. And he's shaking like this and screaming and everything in the middle of the courtroom. And I knew what he wanted. He wanted Mike to sit down. He wanted me to go to the back. And so I tell Mike, I said, Mike, he wants you to go with him, man. I'll see you in a few minutes, And, no, you stay here and sit down, and you come with me. And I mean, he's totally losing it. We walk past the bar and get up by the judge, and the judge is here and the bailiff's over here, and this Robert Summerlin, chief prosecutor for the DA's office for criminal court number 1, looks at the bailiff and says, you make him sit down. Make him stay back there. Make him sit down. And the bailiff's looking at him like, man, you're losing it, dude. And of course, he can't be prejudiced or anything, so he walks up to the bar and says, there's several people standing up back there and talking and everything, and he says, ladies and gentlemen, we're having an issue in the court. I need to ask you all to please have a seat. And so they do, and he takes me in the back and takes me right into the judge's chambers, and they start talking to me about my motions and everything, and then he goes, oh, wait, I just remembered that when I'm talking to you, there's not supposed to be any other parties involved, and I got to take you around here. So he takes me out of the judge's chambers, say this table's the wall, where the judge's office is, to his back. He takes me around to the door on the other side of the wall and sits down at a desk there, and I sit down, and he starts telling me, well, first thing you need to do is get an attorney, and and I said, well, obviously, you haven't even read my motions to even tell me that. Right on there it says sui juris, and sui juris means that I'm capable of handling my own legal affairs and that I don't need an attorney. And he goes, oh, a motion? Like he didn't even know that I filed it, The judge is up there like this, reading it for probably 15 minutes before he even called Summerlin in. So anyway, he starts telling me all this stuff, and I said, and besides, I don't think that that judge even has the authority to hear me make a plea today of guilty or not guilty or any other plea, because I'm still waiting on his oath of office, and I don't even know if he has the authority to be sitting as a judge. And he goes, well, how about I go get the judge and have him arrest you and show you how much authority he has? And I says, are you threatening me? And I was like, are you threatening me? I said, I in no way was ever threatening you, and now you're threatening me of arrest. I said, you're just a DA. You don't have the right to threaten me. I think I'll file a complaint against you for ethics violations. And he goes, what am I going to do? What am I going to do? Puts his heads in his hands right there on the desk and starts saying, what am I going to do? And goes, come on, come on. And he gets back and he takes me back into the judge's chambers. And he goes, Your Honor, I tried to tell Mr. Hardin that he needs an attorney. He refuses to hire one and says he's going to proceed with trial and on his own. And the judge goes, well, Mr. Hardin, I've read your complaint and I'm going to dismiss it. It's frivolous. I said, well, of course, if it's frivolous, you're ready to and prepared to tell me by what grounds it's frivolous. And his eyes just get big. And the DA goes, well, what I'm going to do is make sure there is an attorney around so that if Mr. Hardin has any emergencies, you know, that there will be an attorney on standby for him. And I said, I object. I object to this. I said, there's no way. There might be an emergency on you folks' behalf and on the court's behalf, but I don't perceive there being an emergency on my behalf. And I said, besides, haven't you read Corpus Juris Secundum? The moment you hire an attorney, you admit and give yourself as a ward of the court. And once you are a ward of a court, you look up in Corpus Juris Secundum, and it defines ward of the court as a infant or person of unsound mind who is incapable of handling his own legal affairs. And I said, I don't think I'm of unsound mind, and I'm too tall to be an infant, so, you know, I don't think that that's a good idea either. And he goes, the judge says, well, Mr. Hardin, you know, just think about it. He goes, say you're, you know, out on the road and you're driving. And I said, I object. Driving is regulated occupation for hire. I'm a traveler. And his eyes get all big again, and he says, well, hypothetically, say you're driving down the road and this woman, you know, hits you and she doesn't have a license because it's suspended, and most likely, you know, she won't have insurance either. And I said, well, you know, that's why if you're worried about things like that, you get underinsured and uninsured motorist coverage for yourself, you know. And I said, but anyway, I don't see how this pertains, you know. And he continues to try to explain, you know, hypothetically all these different issues. And I said, you know, I don't mean to interrupt you, I said, but we could sit here for days and talk about hypothetical situations and what ifs. I said, however, not one thing you've brought up so far gives you the right to take my constitutional rights of traveling unrestricted. And unrestricted means I shouldn't have to have a license. I shouldn't have to be worried about if my stickers are good or if my front plate says Jesus is Lord instead of Texas 3TZ dash whatever, you know. And so then at that time the DA's office guy, Robert Summerlin, starts freaking out again. Okay, this can be heard at trial. Trying to get me out of there then. And then he sets it up for trial. He goes up to the front clerk, says Mr. Hardin is going to be going pro se. And I said, no, I'm not. And he goes, well, you just said you're representing yourself. And I said, no, I did not. I never told you I'm representing myself. I am myself. And he goes, well, so Mr. Hardin is going to be here without attorneys, and we're setting this up for trial. And the lady goes, you know, knowing that under Article 1, Section 10 of the Texas Constitution, it says that anyone under as a defendant for a criminal offense has rights to a speedy trial. And I invoked my Article 1, Section 10 right off the bat in my notices and everything else, and she was aware of that, and she knew that. She's looking at the docket and goes, sir, the next trial date isn't till January 22nd. You know, like, this isn't speedy trial that you're trying to do here, you know. What are you going to do? And he looks at me, and at that time I had a driving permit issued through the United Nations that was good in 176 countries. And, you know, I was like pretty upset about this Texas driver's license issue because it was all over a case that had been dismissed. It was over, they got me, I was in an accident, let's see here, back in '99, and they said I was guilty for failure to maintain or control speed resulting in a accident, and then got me for no insurance and on, and you know, vehicle registration and all this. But at that time I did have a Texas driver's license, you know, so they just wrote me my citations, and then I went to court and beat them at trial, and they dismissed it. I filed my motions and everything, and invoked common law jury, and I said, you're depriving me of my rights, you know, here. The legislature has created this municipal corporation that is only required to set forth for people who are under criminal offenses here for 6 jury members. I said, I have the right to 12, neither more nor less. And I filed a motion on Article 3, Court and Judge, and talked about all this, and then a motion for trial by common law jury, which is 12 juror members of my peers, neither more nor less. And so we go into court, and they start getting their jury in there, and I just keep dismissing them, you know. They're not of my peers. I have the right to jury members of my peers, and, you know, this guy says he believes in God, but who is your God? You know, if it's Buddha, then you're not of my peers, because my God is Jesus Christ. And so I'd ask them just simple questions like this, and then, of course, you know, if not that I'm prejudiced or anything, but if they were black or Hispanic or Asian or anything like that, then they're automatically disqualified. They're not of my peers. I'm not prejudiced, but if a black man was in there, he would have the right to a jury of his peers, which would not include a white man, you know. So I kept dismissing them for that reason. Well, we went through everybody they had that day, and then the judge called me back up, and he decides, well, I'm just going to roll on this motion anyway. And I said, you mean the motion you just admitted you've never seen? And he goes, yeah. And so I have my Black's Law Dictionary, and I pop it open. I said, all right, well, right now, invoking, how to say it, subpoena ducis or tecum, I want all court case sites and everything else that I quoted in my briefs to be brought forward and put in my record under subpoena ducis tecum. And what else was it? Well, and then I told them that I'm piercing the corporate veil, because if you don't pierce their corporate veil, then they can do whatever they want, you know. You pierce the corporate veil, they can't hide behind it as it's corporate veil anymore, you know. So you pierce that right off the bat. And I said, okay, and now I'm piercing the corporate veil, holding all officers, agents, employees, clerks, etc., personally liable for any constitutional deprivation of rights that I may incur today during these proceedings. And I went on, and I had my Black's Law Dictionary already tabbed, and the DA, I object, Your Honor. And I look at him, and the judge looks at him and goes, for what? And he goes, he's just trying to confuse the court with all this Black's Law Dictionary stuff. And I said, well, Your Honor, with all due respect, the only reason I brought my dictionary in here is to see to it that the court is not confused in any of the matters before the court, and to see to it that everything and everyone understands the definitions and the wordings that I'm presenting today. Excuse me. And judge overrules, allows me to proceed, and then says that he's going to go ahead and make a ruling on this. And I said, I object, you know, for lack of jurisdiction, and you haven't even seen my motions. You know, you haven't even read them yet. And so he says, well, I'm going to roll anyway. I said, all right, then I need a continuance then, because it's obvious that you guys are trying to deprive me and coerce me in order to extort monies from me, and I think I need to come back with counsel. So he resets it, and then I did a judicial notice. There's a difference between a motion and a judicial notice. When you just file a motion, you're motioning the court to rule in your favor, or you're praying, for the court to rule in a certain way in your favor. Well, when you give them a judicial notice, you're now putting them on notice judicially of certain facts, and they can no longer, like a motion, they can say, well, this is frivolous or whatever. Well, a judicial notice, they can't just say that's frivolous. You've been noticed of certain facts under affidavit, and they are personally liable now because you have judicially noticed them if they continue to let things go like they have been. And so I judicially noticed him, and the next time I was in court, he's reading my judicial notice, and he says, yeah, I see, you demand this and you demand that, and I said, yes, I do, and so at any rate, it didn't go to trial. At that point in time, the judge decided that I had said enough and said, I'm dismissing this, and slapped his little hammer down, and the DA goes, I object, Your Honor. We haven't even went to trial. And he says, I don't think you want to go to trial. As I said, this case is dismissed. And so I get this notice in the mail over this same matter from Linda Boleen. She's the manager of the Safety Responsibility Bureau, Texas Department of Safety, about a year later, telling me that somebody had went and claimed to them that they had damages, and that if I had anything in evidence to prove otherwise, that I needed to present it to them. So that's what I did, and I sent her a letter stating, that I received your letter on 8/20. The papers herewith shall show I went to the courthouse that evening to get the court records that pertain to case number 9624396, as indicated in your letter. The court clerk, Beverly Jones, contacted me today on 8:30 and informed me she now had all the papers in the archives in her possession that I requested, in order that I may properly answer to your letter and demands. I have made copies of said papers and sent them along with this letter to you. As the highlighted area shall show, the court has ruled in my favor in this matter and dismissed the case. That should dissolve request number 2 in your letter. As to number 3 of your letter, Felicia Cormier signed, and what they asked for is the folks that were involved in the accident, they wanted signed affidavits from these folks saying that they didn't have damages by me. And
who are these people who were asking for all this?
The Texas Department of Public Safety, Safety Responsibility Bureau.
And the Safety Responsibility Bureau?
Right. And so what happened is,
like
one of the
SS?
attorneys, one of the attorneys for this other guy, not Felicia Cormier, he failed to show up in court, and so he lost his standing right there. And then Felicia signed and says, I do not wish to testify against the defendant in this case, Felicia Cormier, 52799. And so I get copies of all this stuff, in which, by the way, if it's already archived, you have to pay $3 for a coupon at the municipal courthouse. You have to pay for this coupon for every case that you want. And since I decided to go ahead and pull all my records from the past, year and a half, I had to fill out a separate coupon for every single case and pay them $3 per coupon for them to go to the archives and give me copies of my own records.
Which is just like a fence that they put up to your own information?
Well, of course, yeah. I mean, it's just something else to put you off.
They just don't end.
And again, as it's been stated, that traffic, they learned long ago that traffic citations are one of the best ways to just engulf massive amounts of money from the citizenry. And that's coupons, and then they force you to come to the court, and then you got to pay for their parking, and on and on and on. So, I mean, it's a massive economic industry going on here, and it's all about money. And the bottom line is in another motion I filed for lack of jurisdiction, I stated that the judges were merely revenue agents collecting money for the International Monetary Fund, and which is true because they've all incorporated, and all the money does not go into the state. They go into slush funds here and there and everywhere else. And the bottom line is they are collecting money for the International Monetary Fund, and everything that we as citizens think we own. If you look at your title, say you have a car title, and it's been paid off for 10 years, and you look at it, it says certificate of title. It's not an actual title. You can only have a certificate of title because the World Bank and the IMF hold all the titles and land titles unless you write and do genealogy on your land and show that it was once held in allodial status. And there's two types of titles also, by the way. There's feudal titles, which is like the folks who first came here to America, they were subjects to the king. And so they own nothing. Everything that they thought they owned was really owned by the king, and that's owing vestige, to a superior lord. And so it's held either in feudal status or allodial status, which means there is no one. In other words, they can't come after the fact and say, hey, you didn't pay these $200 on taxes, so we're going to take your home. Well, you can't do that. I own it in allodial status. You don't have the right to take my home because I own it in allodial status, and I don't promise, and I have no vestiges or anything of that sort promising my title to anyone greater than myself or to who I call my Lord Jesus Christ. And He's provided me personally with everything that I have, and the King has provided me with nothing but slavery. And so what happened is, after our folks had our civil wars and stuff in America, they decided that, it comes back to Runnymede, Our folks in English holding titles of nobility and so forth fought their ways through the King's army and put muskets to King George's head and said, we're not sending our wealth and our sweat overseas to you any longer. And if you don't like this, then you can die today. Or you can sign this contract called the Magna Carta, and we will be free men in America now. And that's where the word freemen came from. We became freemen since the signing of the Magna Carta, since our forefathers put their muskets to the head of King George and said, this far and no further. We're drawing our line in the sand right now, right here. And that's what happened. So at that point we became freemen. And somehow, through the World Banks and emergency war powers and stuff like that, they've come back through economics and deceived us all through coercive contracts, unrevealed contracts, and such of the sort, to pledge everything we own to pay the debt of this country's national deficit. And that's a whole nother issue. The national deficit, first of all, when anybody claims bankruptcy, it's added to the insolvency nature of our national deficit. So all these folks, every Congress member, every single member of Congress has declared bankruptcy at least 2 or 3 times. And why? I mean, these people are the ones up there writing the laws and stuff and looking at all the documents and are supposed to be there for the people. And they're claiming bankruptcy and adding that debt on top of our debt, which everything we own, going back to the issue of titles, has been pledged and promised to pay our national deficit. And part of that debt is the interest owed on a Federal Reserve note. You have a boat note, a car note, a house note. A note means that you owe. And when they took our lawful money away, our gold and silver coin, which, by the way, if you go into the records on that, it clearly states that anyone who defaces our coin or robs from our coin, like how they used to, they got the little ridges Well, they would grind the ridges off and make it a smooth coin and still call it an ounce, you know. And by the time the shrewd goldsmiths did this to 100 coins that passed through them, they had a couple ounces of gold. And they were robbing our monetary system. And so there was a law passed that said that for anyone who does this shall suffer death. That is the penalty. It is a felony offense, and the punishment is death. So not only since the president declared us bankrupt in 1933, and then they further down the road kept going on, 1954, 1960s, 1970s, they keep on reiterating the national emergencies and stuff. And that's another argument that you can use in court. You know, hey, we're under the Emergency War Powers Act right now. If we are under Emergency War Powers Act, all courts should be closed. Why is it that you have this massive monetary funnel going on still, sucking the wealth out of the citizenry, when you have it clearly admitted that we are in a state of emergency? And the presidents have all reiterated this over and over and over and over again. And meanwhile, they've taken our lawful money and replaced it with Federal Reserve notes. And what they did is when they created the notes, they didn't create the interest on those notes. So it's impossible to pay. If I say, okay, I'm going to create $10 and I'm going to give you folks all $1 a piece, and you go out into the country and you buy, sell, and trade, and for this loan of $1, you're going to pay me 10% interest on it, you know. And say you go out and you buy, sell, and trade and everything, and you screw everybody you dealt with, so at the end of the year you still come back because there's only $10 in the land. See, I created it. And at the end of the year you come back and you go, here's your $1 back. Now we're even. No, you owe me 10% interest on that $1. Well, where am I going to get it from? It wasn't created. I didn't create the interest when I created the dollars. So it's impossible to pay back. And they know this. They flat out admitted that they are operating in absurdity. They've admitted it. They know that they are operating in absurdity. And then they want to come and say that, you know, we have mental problems. No, you have mental problems. You are operating a system of absurdity, and you know this. You have admitted it on the record, and you've got this debt here now that there's no way to pay back. And what you've done is you created this world peace organization called the United Nations, and everywhere that they go, every single country they've went has not been peace. It has been famine, war, and death. Everywhere they've went. They've never went anywhere where there's not been famine, war, and death. They are not a peace organization. The land was donated by the Rockefellers. The building that sits on the land was donated by the Rockefellers. Is this a coincidence, you know? I don't think so. There's a small elite group who have no interest but their own, and the Silent Weapons for Quiet Wars Research Technical Manual 73-949, I believe it is, they outright admit that they have declared war upon the American people through economics and what was it? Economics and brainwashing. You know, so they've created a system, and they figured out back then, this small group of elites, this was back in 1954, and then the manual was written in 74, I believe, and it's clearly or 72, it clearly states in there that they've declared war on us, and that they figured out that they could control the world through a push of a button. And, yes?
James, you mentioned earlier about titles, including a allodial title. Do you know, or do you know of anyone who does know how to proceed with getting an allodial title to property if you have all the property genealogy done?
Yes. You first just have to do your genealogy on the property to prove it was once held in allodial status.
Okay, how,
And if it was ever held in a allodial status, it could never become feudal again. Once it's allodial, it's owned outright, it's been paid for. There can't be any debts placed upon it. And so, if you can trace, well, and the other thing is you got to have it paid off. You can't owe a bank and try and get a allodial title on your property.
but if you can go back, this is just an example. I own a piece of property that is paid for, and I can trace the property's genealogy back to the original Texas land grant. Is that, would you say that's enough genealogy?
Absolutely.
Okay.
Absolutely. Because if you've got it back that far, it shows on there that it was held in allodial status. So if it was held in allodial status then, and now there is no debts owing on it, you know, you didn't borrow money from the banks to purchase this property, and it's paid off in full, then you should be able to get allodial status on that property.
Who would you send your notices to? Where would you send them, and how long does it take to get a confirmation back?
It takes, depending on how you process your information, it could take different periods of time. There is a couple in the AAT, Chuck and Carolyn Gard, and they have done this and have received their allodial status on their home. And their home is in the middle of a nice subdivision. And the bottom line is they paid that home off and then proved that the property that home sits on was once held in allodial status. So once you get to that point, then it doesn't matter, you know, if a house is on it that didn't used to be or whatever. But to tell you the truth, that would be the one that I would suggest you talk to, because they have personally done it. But the bottom line is, if you can prove it, and if it's paid off, and you've done the genealogy to prove that it was once held in allodial status, then you can get it in allodial status for yourself. And once you have that, you pay no more property taxes. There's 12 million Amish, I believe, in this country that do not pay taxes. They do not pay property taxes, road taxes, any of this. And they own all their property outright in allodial status. Now, their roads may be a little rough because the state's not going to come in and pay for their roads to be redone, because they're not paying them the taxes for that purpose. But you know, that's a fight that you got to be willing to either deal with, the chug holes in your road or not. You know, you might want to be free rather than be a bond slave, and the little chug hose might be a small price to pay.
What's the definition of allodial status?
Allodial means
Allodial or illodial?
allodial, A-O-L, allodial. And it means owned outright. There's no vestige or homage owing to any superior lord. If you
Well,
look
it's
at
like
it.
alodial
Right.
would be like asexual, meaning without, you know, without a load, without someone above it
Right,
holding it down or holding it entitled to it or
right.
something against it. On the outside of allodial.
A simple explanation means that you actually own the dirt.
Yes.
Because any other type of title means that all you own is the air above the surface.
It doesn't even mean that you own that. It means that you're being afforded the opportunity
You're given the privilege.
exactly,
Uh-huh.
the privilege.
But if you have a allodial title, you own the
That,
dirt.
yes, absolutely. And I kind of got off track of traffic, but the reason was so that you guys could understand the whole bigger picture and understand why it's all coming together, and why they're creating municipal corporations, and Harris County Corporation is specifically mentioned in my Title 42 lawsuit that I'm about to file. And Harris County is mentioned because they are a municipal corporation. And on page, and see, the bottom line is the fact that I was telling you about this foreign agent issue, you got to look at beneath the surface of these people and their organizations. And the whole way, I mean, like for Secretary of Treasury, for instance, Robert Rubin, he is now, by Title 22, international organizations, been declared to be the governor of the fund and World Bank, which is clearly not any part of the American, land or country or the several states of the Union. They are a foreign entity. And if you believe on simple biblical principles, no man can have two gods, for he will love the one and hate the other, or cling to the one and despise the other. And if you look at it under those circumstances and you go, wow, man, how is this guy the Secretary of my Treasury for America, yet he's been appointed as the governor and receiver of our nation's national deficit? Conflict of interest. He is representing a foreign power. And to try and hold an oath-bearing office such as Secretary of the Treasury of the United States of America, I mean, that's treason against his country. Because every man is going to be, how can I word it, loyal to the hand that feeds him. And if you are paid by the World Bank and International Monetary Fund, then how can you be loyal to the citizens of America and the several states thereof?
You're right.
So, this is a massive conspiracy, and traffic is just a small portion of what they're doing. And that's why I got out into the bigger scope of it all. So Harris County has created this, I'm trying to find it here. Do you remember where I mentioned that? Under actual background. In the copy of this title, it's a rough draft, by the way, it hasn't been filed yet. It mentions the incorporation of the county.
Which document?
This is the Title 42 lawsuit that I'll be filing against the judges and the attorneys and the officers in Harris County, and John Doe's and Jane Roe's 1 through 100 that will be named after further discovery. So, they've come in and incorporated everything, and all corporations get double taxed, and then it's a massive conspiracy. So the whole point to telling you all this is there's a billion reasons to go in and object to the jurisdiction right off the bat. I mean, either they're foreign agents, they're members of the bar, which has, again, private dues-paying, card-carrying members to a private club, and they're not any part of the local, state, or federal government. And now you'll find that the State Bar of Texas is writing legislation for us. And I'm like, what? Conflict of interest, man. How can this private club write the legislation for the laws that will apply to the citizenry? But it's the same with the IRS. How can the IRS tax us when they are no part of our government? And they're not. They're a private entity. And that's how they do it. Bottom line, it's all through smoke and mirrors and deception. And if you don't go in right off the bat and object to them and object to the jurisdiction and tell them you don't have jurisdiction, I'm a living sole plaintiff, I bleed. I'm not a fictitious creation of paperwork, Yes.
I've been kind of doing things along those lines too. By going through the codes and analyzing what the person is, it's generally going to be a corporation.
Yes.
It's most clear in the Code of Criminal Procedure.
Yes,
The only place that defines person is Article 1780. There it says person, he, him include corporation association.
Right.
Provides
Or
no
partnership and
then there's Rule 52, Texas Rule of Civil Procedure, alleging a corporation. There it says that allegation of corporation, they seem to be correcting us affidavit submitted by the adverse party.
Right.
So basically, all you do is put in a affidavit, let them know that you're not a corporation,
Right.
and they know what they're doing, which municipal and justice courts really don't, for the most part. And some way or another, it tends to go away.
Right.
They'll never say that that was good paper and that's why we're doing it, but
Right.
It
Well,
goes
you're
away somehow or
absolutely
another.
right. You're
I would
absolutely
imagine
right.
if they really want to be successful, they have to find the stupidest people they can to work for them to
Well,
just
of
do their
course.
bidding.
And it mentions that in Silent Weapons for Quiet Wars. It says that the education provided to the lower class citizenry must be of the poorest sort. That way they can never figure out, all the stuff that's going on and how they're being raped and everything. And everything they own is being stolen from them. And they said that this is a necessity for the inferior ruling upper class to keep some sort of social order maintained. And they outright admit that these folks who will not use their brains are no better than animals who have no capability of using their brains and are the same as steaks on the table.
Yeah.
So if you go in and hire an attorney right off the bat, instead of going in on your own and objecting to them appointing an attorney or anything, the moment you do, you're subject to the court, or ward of the court. When you're a ward of the court, you're immediately defined as an infant person of unsound mind who is incapable of handling his own affairs. In other words, you're stupid. We know that, or you wouldn't have hired him.
Right, you surrendered in effect.
Exactly. And you've left your rights behind at that point.
Wow, that's pretty true.
Yes.
James, that trial or hearing that you were describing with the DA and the judge earlier,
Yes.
at one point in time I thought you said the judge said he was going to dismiss the case, but that didn't end up happening, did it?
No. I'm going in Wednesday. Since got records I faxed in. See, I sent this stuff all to them, the records that I went to the court and paid for their little coupons and everything to get my own records. And I sent it certified mail. Everything you send any government agency or so-called government agency, don't send it unless it's certified mail. Because they'll say, we didn't get it. What are you talking about? Meanwhile, my license was suspended for a year and I didn't even know it. And they never answered me back. So meantime, I'm thinking, okay, well, they must have cleared it up then, and I don't have access to a police computer or anything, and I didn't get pulled over, so I didn't know. Well, then I get pulled over, and they say, hey, your stuff's suspended, man. I should be taking you to jail right now. And thank God the Lord was with me, obviously, and He was a man of character, and wasn't one like I met today who was totally abusive of his authority. So I called him up and I said, listen, I got certified mail return receipts here that your agency, Safety Responsibility Bureau, Texas Department of Public Safety, received this September 5th of 2000 by Joe L. Rodriguez. And, oh, really? Our computers don't show you even responded. So she says, fax this to me. So I faxed it to her. They realize the state's in error, and they immediately reinstate my license, which is, by the way, a government-granted privilege to do something which would otherwise be illegal or unlawful. So keep that in mind, too. The definition to license is a government-granted privilege to do something that would otherwise be illegal or unlawful.
Right, I've heard that phrase a lot. Driving is not a right, it's a privilege.
It is. Driving is a privilege because driving is regulated occupation for hire. You are not a driver, you're a traveler. Every living soul or citizen has the right to travel unrestricted down the highways and byways of the several states of the Union without being harassed or restricted or saying, well, you can have this right so long as you pay me $80 to register that truck and go get this smog test for $40 and make sure you got some insurance. It costs you $100 a month, and then you can go. Well, that's a restriction on my inalienable right to travel. You know, all of those are. And you have to argue that point. And they will, of course, come back and say, well, it's for the necessary safety and well-being of the general public. Well, who says that? You? My forefathers, who bled the grounds red, gave me my rights. And the one that gave them rights were the ones, like when Christopher Columbus wrote in his personal diary and journal on his way, he said that he didn't know where he was going, but he knew it was possible because the Lord was leading him through divine scripture. And our first Constitution, Bill Martin's aware of this, through Connecticut, wasn't it? Which one was it? The first one ratified?
Delaware was.
Delaware, yes. It outright says that who their oath is to, and it's to Jesus Christ. And this has been from the inception of our country. And if you look around, our Constitution is the only one that has stood for over 200 years. And why? Because all laws, rules, and regulations repugnant to it are null and void. Take a break? Okay. 4 minutes? Okay.
Let me say something. When you challenge that authority, though, James, what you should do, have you ever read that case about Lansing versus Smith, 1828 case?
No, sir.
Oh, y'all probably like to get it and use it. Good case.
All right.
Tells you who you are.
Yeah.
It's interesting.
Yeah.
But going back, if you got another minute on these tickets, most people don't understand where this money goes. When that ticket, when you get a ticket today, and it hits that courthouse, or downtown, wherever it goes, county, city, wherever, it becomes commercial paper.
Right.
That means that that ticket is already, somebody bought that, say it's $100 ticket. Somebody in powers to be down there has bought that ticket. They might only give $20 for it, but they bought that ticket. Now, when that ticket is paid, they get the money.
Right. It's like buying out a loan.
Right. So it's all just a big old scam.
So where does the money
Somebody
go?
goes in. Pardon me?
So where does the money actually wind up? In whose pocket?
Well, whoever buys that ticket owns that ticket.
Well, where did they buy the tickets from?
They bid on it. You know, the judge might own it. The judge might decide he wants it. Or whoever's in the power now. There's just a very, very few elite people now that can buy it.
Can you FOIA that out, shit like that?
Yeah.
What's that? Can you do
And
FOIA
they didn't cut it
requests
down
for
right
that?
away either. Say that again? I said our forefathers used to hang people like that,
Oh, yeah.
and they leave them there.
Comprehensive annual financial report.
Yes. That's what I was referring to when I said slush funds.
Okay. In 1998, the state of Texas, now every entity has a separate set of books that they hide from the people. They got one they let you see, which is always in the red.
Right.
And then they have this other one called the CAFR, which is Comprehensive Annual Financial Report. Now, in 1998, when I first heard about this, Texas, just the state of Texas, had over $6 trillion in that account. Now, that $6 trillion, they could give every man, woman, and child in the state $1 million and still run this state from now on with just the interest that the rest of the money would make.
Right.
But every state, every county, every city, every public entity that takes in money has a separate set of books.
And they've now incorporated them all also. So what happened to our Republican form of government? It's obsolete now. And until
Since 1860.
until we come in and say we have the right to a Republican form of government, and I am here today standing on my forefathers' grounds, and I am reserving that right to myself and taking it again from you. And if you guys want to know more about that, the John Nelson seminar goes into that extremely deep. And they're available here, the tapes. man, 90 minutes of tape. I believe it was 4 or 5 days worth of seminars, and they are 30 hours, I think, excluding breaks. None of that stuff's in there. And it's over 4,000 pages of certified documents, court documents and stuff like that. And there's motions in there and stuff also that talk about our courts and how 44 federal judges where they seized a daycare center, and they were suing. It's Atkins et al. Versus U.S. Atkins et al. And well, the daycare center was a separate issue. I'm sorry, but 44 federal judges went to the government and said our guaranteed compensation is being diminished. And by the Constitution, Article 3, it says that in no way can our compensations be diminished in any way. And we will no longer uphold the law or any substantive remedy thereof until all of us judges are dead. And they sought relief from 1969 to 1970 something, 6 or something like that, with interest and penalties on the deflation of our new Federal Reserve notes, and said that by receiving these notes, and since there was deflation of the notes and they became bills of debt credit, that their guaranteed compensations had been diminished. And in their report and in their prayer, they declared the people and the children as a large club who had no remedy, and sought protection for themselves at the demise of the people, knowing that such heinous acts had been committed against the people, and sought protection for themselves only, and classified us as a large club who had no remedy. And if you look that up, it's Atkins, Atkins et al. Versus U.S. And there's copies of that case in John Nelson's seminar material. And I mean, it just goes on and on and on and on, where these folks holding public offices are well aware of what's going on, and they're doing nothing about it.
One thing on that CAFR, a judge can sit on the bench for 1 year and draw $5 million out of that account, the CAFR account.
It's amazing.
Drawn out for what?
For whatever purposes he thinks necessary. Like he may think it's necessary to have a new home. He thinks he works hard and he deserves it, and he can demand it.
Interest in taking your money.
If you read those cases in that John Nelson seminar, you'll also see where senators and stuff can go into our depositories and draw up to $10,000 out a year. Just walk into the doors and go, "Hey guys, I'm here. I won't."
When you said the judge, it dismissed it.
Yes.
If you had said it to give him to dismiss it with prejudice, then they can never bring it back up again. Is that right?
Right, and that's what my motions all say. And in fact, this one here, the end of it is the prayer, and it says, the act in question is a valid regulation, and as such is binding upon all who use the highways for the purpose of private gain. Any other construction of this statute would render it unconstitutional as applied to the citizen or any citizen. The accused therefore moves this court to dismiss the charges against him with prejudice. So you always want to ask for that.
Right.
Always ask for it to be dismissed with prejudice, because then you've created a case site precedent. And not only that, but these motions that you have copies of now are in their appealable form already, as I was saying earlier. Not one definition, not one case site, not one ruling in this entire motion has been overruled. It's been shepherdized. They all still stand to this day. It doesn't matter when they were quoted from, 1800s, many of them from the 1800s. And it defines what an operator is, and what traffic is, what a driver is, and let's see, the surrendering of the rights, and vote and quotes under there, Riley versus Lazon, and Stevenson versus Benford, Supra, and Hope versus Henderson, Simmons versus United States. All these cases quoted in these briefs have never been overturned. They still stand as case site precedent to this day. So for a judge to tell you this is a frivolous motion, well, I'm now questioning your competency, sir. Either you have a personal prejudice against me, or you're just outright incompetent because you don't know the difference between a valid brief and one that is frivolous. And that was another thing that I told him that day in the judge's chambers whenever the DA started screaming, okay, all this can be heard at trial. And then consequently, I called down to the court clerk and was trying to find out some information about my trial date on 1/22. And she says, well, I don't show that's set for trial. I'm like, I had a witness standing right there, and he told you set it for trial. And then she says, yeah, he came back and had me change it in the computer to change it to hear motions now. Oh, so now you've not only just denied me my right to a public and speedy trial, an impartial and speedy trial, but you've now changed the non-expedient trial that was 3 months later from the trial to a hearing to hear motions. You know, I mean,
not on the record either, because they didn't say it in front of the courtroom.
Exactly, but she admitted to me that the Robert Summerlin came back and had her change it in there to hear motions. And I have my case reset form right here that clearly states it's set. The undersigned defendant and counsel acknowledge this case is reset for trial. Not to hear motions, it's set for trial.
Is that a felony, what he did?
Well, I think it's fallen under the RICO statutes, because when two or more conspire together to commit a fraud, it's a RICO action.
Something that can be considered ongoing.
Absolutely. And not only that, but as you'll see in the copy that I give you of the rough draft for the Title 42 complaint, it states in there about the same things, you know, that how the fraud is just ongoing and
See what I was
ongoing.
saying before, but they need to have, their weakness is that they need to have unscrupulous, low mentality people like this guy to do their bidding. That's their weakness. That's why he freaked out, because that's an affront to him personally. He's mentally so small. For anyone to question what he says, he just freaks him right out.
And they're not used to that. They're used to going in there and their God.
Absolute power.
Absolute power, you know, and it's abusive power, by the way.
Did he have a gun too?
I didn't see it, but he definitely didn't try it on me. But bottom line is when folks just go in with attorneys every day, you know, they run amok, because they know that they've got a lynch hold, and we have an attorney here tonight who knows about this personally. The bar has a chokehold upon all them attorneys, and the moment they decide to do what is true and what is right and stand up for the truth,
They're under the club.
exactly, you get disbarred. And then if that's your only source of income is being an attorney, what do you do then? You know, now they've forced you into poverty, and they've done that for years. That or just flat kill you. You know, for instance, John Nelson's sister was a high-powered attorney working with the government on all these federal land deals, where the government's coming in and taking all of our land and turning them into federal parks and stuff, yet we're not allowed on the land. Well, it was our land, you came and stole it from us, and then says we can't come on it no more. Well, she was giving him information, you know, copies of documents and stuff like that, and ended up dying of unknown causes. His brother got blown up on a tractor, and the blood's still in his house from when they murdered his child, one of his daughters. And everywhere he goes, if he gets on a plane, he's got a bodyguard with him. The people I learned from, Robert Carey in Las Vegas, Nevada, the IRS came in, took $200,000 out of his personal safe, seized everything he owned, his business, his cars, his house. He was reduced to living in a pull-behind-your-truck little trailer in his mom's backyard, and this guy was a millionaire. And they just hit him hard, and he was introduced to John Nelson, and next thing you know, massive suits. I mean, defendants take a whole page just to list them. I mean, this section right here, I mean, they're just one after another. Secretaries of Treasury, IMF, the World Banks, all of them.
Well, where are they going? What's happening with them?
They're still going, and they filed separate suits later because the courts tried to fraudulently dismiss his case, and he says, hey, now I'm suing you for fraudulently dismissing a valid case. And so they have massive suits going, and he had threats on his life, so now everywhere he goes, he's got a bodyguard with him.
How can he afford that now?
Well, because the cases that he wins, he demands payment in lawful dollars, gold and silver bullion, and lawful dollars minted by the U.S. Treasury. And if you ever buy gold or silver, you know that for a silver dollar, it costs you $10 to get that silver dollar. But it says dollar on it. It don't say $10 or $20, or it says dollar. So he asked for $5 million in gold. Well, $5 million in actual dollars, I mean, just figure it silver-wise. I mean, you know, what's the difference in the price of gold and silver, and what's the difference in that compared to our paper bills of credit, you know? And the state, John Nelson won a case once in Colorado, and the state paid him with a check. He says, that was the last check they ever gave me. Because then he sued him for giving him, you know, he asked for lawful dollars, you know, and they paid him with a check, you know, and there's interest-bearing bonds and everything else from the government placed on these Federal Reserve notes and stuff, and he didn't have access to lawful dollars, and so he sued him for, shoot, how did he do it, man? I'm trying to remember now. The bottom line was fraud.
You can't pay a debt with a dead instrument.
Exactly. And when he filed under those circumstances, and he won, and he said, he ain't tried to pay me with a check since.
If you want to know where to get that information from, look on the United States Code, Title 12 and Title 18 and Title 31. Surprise you what you might find in there.
Yeah.
How long did it take you to learn all this stuff?
Well, worked for Robert Carey in 1996, and he held a meeting with everybody in his company, and I was one of the new guys, and he said, this is how I pay gold and silver coins, lawful dollars of the United States, minted by the United States Treasury. And I don't take taxes out of your money because I'm not a third-party collector for the Internal Revenue Service. And I'm not going to keep their books and their paperwork for them for free. They want to keep your books and records, let them do it. He goes, but I'm not going to pay a secretary to work 40 hours a week to keep up with your books and records for the IRS. I will pay you lawful dollars, which the IRS does not have the right to tax, and because they only have the right to tax their money, their fraud. You know, they don't have the right to tax lawful money. And so anyway, he says, this is how I pay. Any of you have a problem with that? It's not a problem. You know, you can go right now. And I'm sitting there looking at this guy going, what? You don't pay taxes? You know, I'm all freaking out. Dude, man, you're going to get us all arrested, man. And so I worked for this guy, and I started reading some of his stuff, and this was in Las Vegas, Nevada. And they still have cases going there. I can give you guys the sites and stuff like that, so you can go and pull the records if you'd like for yourself. But he has over 1 million documents filed in the state court, and they keep trying to take it into the federal court, and they keep going, nope. District Court has original jurisdiction for the Republic of Nevada and the citizens thereof, and this is where it's staying in state court. And you read his transcript from the court, and at one point in time the judge actually tells him, you know, I ain't going to do this or that, you know, and Robert Carey tells him, what do you mean you're not? You have to. He goes, have they threatened you? And he goes, well, no, but I'm not going to jail with you. The judge tells him just like that. I mean, what do you think? They've obviously been conspiring in the background, man. The judge is already telling you the outcome of the case before him. I'm not going to jail with you. You know? So, but you're dealing with, and he flat out said, he said, I've told you, and it's in the court transcript, he says, I have told you last week, Mr. Carey, that I hate the IRS too. But they are bigger than you and I. The federal government is bigger than you and I. And I ain't gonna die over it, you know? And it's right in the court transcript, man. It's amazing. You know, I mean, you read it, and it will just, it's almost like, I don't know if you've ever had like a divine revelation, you know. People say God talks to them, you know, and I'm like, what do you mean he talks to you, you know? You hearing voices and stuff, or what? But when I say the Lord spoke to me, it's because I prayed, and it was an immediate knowing. You know, the question I asked, I immediately had the answer to. You know, I didn't hear a voice go, the answer to your question, son, is blah, blah, blah. You know, it was an immediate knowing, you know. And that's just a whole nother issue. But anyway, back to the traffic matter. You definitely want to file the notice to the city attorneys. You definitely want to start out by getting all their anti-bribery statements for the officers and stuff, because if the officers don't have an anti-bribery statement, he's not a legal officer. You know, he's no different than me coming out there and putting little lights on my truck and saying, pull over. You know, okay, you're going to meet over here at Hardin's garage for a trial on the 28th, you know, and I'll decide if you're guilty or not, you know.
Bring plenty of money.
Right, and bring plenty of money, because I might hold you hostage in the doghouse and back if you don't, you know. And that's the difference, you know. There is no difference. There is no difference between what I just said and that guy with the gun and a badge on and driving a car that's marked police. If he doesn't have an anti-bribery statement on file, he is not an officer. And if that judge don't have an oath of office on file, he's not a judge.
They're impersonating.
Exactly. They're acting.
They have to have an oath?
Yeah, they have to have an oath of office. Every judge has to have an oath of office.
Every public official.
Yes, has to be sworn in.
Even
On
a
file.
board member.
On
Yes.
file with who?
On file with the Secretary of State. And that,
It's Article 16, Section 1 of the Texas Constitution.
and by the way, this was a mistake I made on this, and I appreciate if everybody would cross out my credit card number.
I wondered about that.
Yeah.
I said, geez,
I'm like, man, it just hit me. I'm like, woo, just give out this with my credit card
You
number.
change a couple of digits on that?
Yeah.
Is the other one in the computer? You might want to go get that one right now.
No doubt.
Because they can go in and, you know,
Yeah.
do all kinds of fancy.
Yep.
Plus, I shouldn't have faxed this to all my friends up in New York.
So what you do is you just put your credit card number on there or whatever. If not, you can. That's to have it, you know, overnighted and to have it immediate if you want it processed quickly. You know, I used a credit card.
Don't cross it out, your number.
You can
Yes.
also do this by email. I've done that.
Yeah.
Really?
To Riegler. Yeah, he'll take it and you give him the information and he'll do it.
What's his email address?
I just got a couple bills to pay.
J. Riegler at sos.tx.us or something like that.
.gov.
Or something.
I don't remember off the top of my head. It's been a while since.
And also, when you send out to the Secretary of State, you want to, what they'll do a lot of times is when you ask for this oath, they don't have it. and then they contact them and say, hey, this guy's just requested, your oath, and that's not on file. So they run down there and they get an oath done and swear in, and now they send you a certified copy of his oath, which is absolutely valid now. So what you do is like
You
here.
have to have the date on where you took that oath. So.
Well, you're right. And if you don't want to continually fight more battles than necessary, you alleviate it in the first letter. Like this one, I said, I want the oath as of November 1st, 2001 or prior. So don't come to me with an oath of office dated after that date, because these incidences happened before November 1st. So I want their oaths as of November 1st or prior, So if it's January 25th of 2002 that you were arrested, then you would say, I want their oaths and anti-bribery statements as of January 20, blah, blah, blah,
See,
2002.
anti-bribery statement, that's in the county. You have to go to the county to get that.
No, you can get it from the Secretary of State.
Secretary of State,
Yes.
oath of office is local.
You can get it local or from the Secretary of State. She didn't like me.
You have to pay them with a credit card to have them do
No,
this?
you can send them. I just did that because I wanted them overnighted. I want them quick.
Right.
And usually, if you just send off for one thing, it'll happen quick. But the deal that I asked for here that they had problems with was the foreign registration of foreign propagandists and foreign agent registration statements. They know that they're representing foreign powers.
Yeah.
And they know they don't have this. And the penalty for representing a foreign power and not having said registration on file is 10 years imprisonment. So that is why, to this day, 1 month later to the day, I have not got any of this information back from them. And usually when you do it with a credit card and ask them to FedEx it overnight and charge it to your credit card, it's there in 3 days. You got their oath or their anti-bribery statement.
Now, one other thing, James, excuse me. On a judge now, if he's a visiting judge, see, visiting judges are unlawful because every time a judge changes court, if he goes from one court to the other, he has to have the oath of that court.
Right. That was right.
So, just because he might have it from one court, but if he's a visiting judge over here, he's unlawful unless he has it with that court too.
That's true.
Wow.
That's a good point. Very good point.
Yeah, you're talking about that. I know of a guy who's done a suit up, I forgot what county, but a little ways north of here, to get property back that was sold at IRS auction in a trespass by title. And it seemed like the district judge didn't want to do it, so the day it's supposed to have a trial, well, he was too busy with a jury trial, so they turned it over to another judge, which was the county judge there. Well, everything went against him. And he goes to the information Secretary of State, and he asked for a new trial, and I said, oh, okay. No trouble.
Right. Yeah. Yeah, that's another thing. If all fails, it ain't over. And even though they tell you, you have two options, okay, and say they had a mock trial, okay, and the judge only gives them certain points to rule on, and you should also have a jury foreman. Every jury should have a jury foreman who informs the rest of the jury of their duties and their rights as a jury. And the judges don't like that. I've had to remind them several occasions, you're not the judge. And because he says, this is my courtroom. And I said, I object. This is the people's courtroom.
That's right.
And it is not your courtroom. He says, I'm the acting judge here. And I said, I object. The jury is the judge. You're just a referee. And he goes, oh, now a judge is a referee and a referee's a judge. And I said, absolutely. That's the way it is. The only reason you're sitting there is to make sure, as a referee, that everything goes by lawful proceedings and that these DAs and attorneys don't have a mock trial. You're there to prevent that because these jury members here, they're not schooled. They didn't go to law school and stuff like that. So they don't know when something like that is going on. And you are merely a referee here to see to it that that doesn't happen. But as far as judge, you're not a judge. You might be called a judge, but you're not a judge. They are my judge right there. Those 12 people in that box right there are my judge. And that's a fact. They are your judges. In the end, they render your judgment. Guilty, not guilty.
But he passes sentence, right?
Well,
They don't want to take it out.
no, they do.
Jury does.
No, but do they say, then he'll say, okay, like guilty, okay, then who says, okay, 25 years and $1 million, so who?
Well, no,
says that part?
he as the referee will give them options that are set up by law. You know, for these crimes, the penalty is this amount of time in prison, up to this amount of time in prison, or this amount of dollars of fines, up from 2 to 200, like Bill Martin was told. And they found him guilty and fined him the maximum $200 on every single one of them. And that can happen. And then at the end, the judge can tell you, well, you have two options. You can pay the money now, or you can appeal it. And you say, I object. You're trying to coerce me. And he'll be like, what do you mean? I object. There is more than two options that I have. I can call for trial de novo, and trial de novo means set a new trial as if the first one never happened. And everyone has the right to trial de novo. So you can totally get rammed and railroaded, and it's not over with. It's okay. You don't have to know how to appeal a case. Just go trial de novo. I want a new trial, and you can get it. You can get it.
On what basis?
You don't have to give a basis. You just say trial de novo, and it's your right.
A certain judge denied it to me.
Well, he's
Of course, I'm
See,
on
they're confusing common law court with equity courts. So, and the jury and the judge, see, when they keep talking about the judge do this, do that, he can do whatever he wants to in administrative court.
right, and that was my point earlier. You want a judicial proceeding, not administrative
That's right.
proceeding.
What about in family court?
In family court, you want a judicial proceeding also.
Always good.
Always
Family
judicial.
court is administrative exclusively, isn't
And
it?
so you ask for a judicial
And
proceeding.
don't go into it. Just tell them you're not going into it. You want to,
Object
object to it.
right off the bat and ask them. Say, Kenny O'Kane was in a case for taxes, and the first words out of his mouth was, is this a administrative proceeding or is this a judicial proceeding? And the judge goes, it's judicial and administrative. And Kenny's like this, and he goes, are you with me? And Kenny goes, no, I don't think so. You can't have it both ways. Judicial, you can have, a judicial proceeding is where you have constitutional rights, and they cannot deprive you of those rights in a judicial proceeding. In administrative, they can quote legislative enactments that are contrary to your constitutional rights, trespass on them, spit on them, and throw them out the door. Bottom line. And actually, since ever since they first of all, any bankrupt entity is no longer that as it was before. So the moment the United States declared bankruptcy, we were no longer that as we were before. That's why you used to see on the Olympics and stuff like that, you'd see the United States, Now you hear the corporate United States.
Really?
That's why. Absolutely.
You hear that now?
Absolutely. The corporate United States. They admit it. They admit it.
The corporate United States
On the Olympics, they will admit the corporate United States.
Oh, come on now.
I'm telling you what I've seen and heard myself personally. I'm not telling you hearsay. I'm telling you what I've been there and done that. Studied it, seen the documents, or heard it and saw it myself.
Okay, so we send out our notice, so we get a ticket. Let's say you're driving down the street. So we send off this notice to the secretary for now should you do all of them?
Well, it depends on, where you plan to go.
Okay.
I asked for all these because I plan on making a real big case.
See, let me say one thing, if you don't mind. When you go in there, you got a right to the nature of the cause. and a copy of the complaint. Tells you that in the Constitution.
Right.
All right? A copy of, you want a signed copy, a sworn to signed copy of the complaint.
It's called a verified copy.
Yeah. Now, the county clerk is one that always signs that complaint. See, they're swearing they was out there when this happened and an eyewitness to it.
Yes.
And there was no, and they were.
And that's grounds for dismissal right there.
So I asked for a verified copy of the complaint
Yes.
after I get this stuff from them, before I go to court.
Well,
This,
you
then
get
I
this.
there, I go ahead and ask them for that.
And you file a motion invoking the common law jurisdiction of the court, and objecting, a notice of motion for dismissal for lack of jurisdiction. Every time, lack of jurisdiction. You are lacking jurisdiction to even hear this matter.
Yeah, another thing,
One other thing you need to do when you go in there.
Hold on now. Common law motion for dismissal, lack of...
Jurisdiction.
Okay.
Now, you need to go in and challenge the law itself. Show me the law that applies to me. The law,
Another
some
point
code or
of
some
jurisdiction
statute,
is,
some regulation.
is Article 5, Section 12 of the Constitution. It says presentment of indictment or information invests the court with jurisdiction. Well, they don't ever do that in practice cases.
But see, it's still criminal, and you can go in front of the grand jury. You need to go to the grand jury.
Well, it states that clearly in Texas Constitution, Article 1, Section 10, that before you can be indicted, you have to have your right to a grand jury indictment. So if you're not indicted by a grand jury, and if you go in there and say, Mike Hawkins is my co-counsel, and I am myself, and I'm not representing myself, I am myself, and they say he has to be a member of the bar, and you say, show me the law, like he's saying.
Yeah. Always
Under
show
Article
the law.
1, Section 10, it says I have the right to represent myself or by counsel or by both. Where in there does it say a member of the bar? Where does it say attorney? It doesn't. It says counsel. He's my counsel.
And the federal Constitution tells you have a right to counsel.
I argued that before an associate judge, which is a non-elected judge, as you know. I didn't know it at the time. And the fourth definition of counsel out of Webster's dictionary was a counselor at law. The three prior definitions had to do with someone that gave you advice or information.
Well, still, even with that definition, I didn't hear member of the bar. And I didn't hear attorney. So where do they construe everything to become, you have to be a member of the bar? You don't have to be an attorney. You don't have to be a member of the bar. And you cannot produce documents that back up what you're saying. You're talking, but you have no evidence to back up what you're saying. If you don't have evidence to back up the talk you're talking, then don't try to walk the walk, because you're not walking over me. Not with the talk. You got to have evidence, And if they can't produce it, then just keep objecting. I object. You're violating my constitutional right to my choice of counsel. And my choice of counsel is this 6'7" guy with the big old red beard, 300-pounder. And no, he's not a member of the bar, and no, he's not an attorney. But you're saying that he has to be. Well, prove it. Show me the documents.
Show me the law.
Right, show me the law. That
Always
says this
remember, show me
stuff
the law.
that you're talking about.
You also cannot use a Webster's dictionary in a courtroom. You have to use a Black's Law Dictionary because they're very, very different.
Yes.
And a definition out of Webster's carries no authority in a courtroom. It has to be Black's.
And as does Black's Law carries no authority in the Supreme Court. There's only one dictionary recognized in the Supreme Court, and that's Bouvier's.
1856 Bouvier.
Right. And 1856 Bouvier's is what's quoted in these motions. So,
Well, that shouldn't be. It should be common.
well,
Common dictionary for the common person to
Well, they
understand
shouldn't go by the
common
law.
language that's
Right.
used.
see these other dictionaries.
That's in conflict with the objective of government. They got to keep you confused.
See,
They'd like to.
there's one other thing too, when you, on this grand jury, what the DA will do, he said, well, I have information of so and so. I have a very, very serious problem with that word information being in there. Now, if he does do that, ask him to show me the information that you have. And he said, well, I have this witness supplying me with the information. But the law says 2 or more witnesses. It says witnesses.
Right.
Got to be 2 or more.
Right.
Maximum law, 1 witness is no witness.
Right.
See? But I really have a problem with that word information that they slipped into that Constitution and that state Constitution.
Yeah. They have.
Because they can go out there and yoke up some junkie somewhere.
Right.
And, you know,
And that's what they do, exactly
Sure.
what they do. They have their little informants and stuff. They busted with heroin and everything else, and they make deals with them, you know.
yeah.
We won't
But
throw
that's
you in
reason,
jail,
see,
but
Jesus
you're
said,
going to be an
bring me-
informant for me now, and then whenever they need a fumble bunny or guinea pig in the court, they use them.
Yeah,
That's the reason
they're not
Jesus-
as much of an informant as they are a mannequin.
Reason
Right.
Jesus said, bring me
Tell you
2
to say.
witnesses.
You know, we're
2
not asking you for
witnesses.
information,
Bring
we're
2.
asking you for
Not 1.
performance.
Yep,
That's where they come from, everything.
that's a fact. So you get that information on them, and then you file in as an exhibit, exhibits, and you mark your exhibits. You know, exhibit. I like doing it A1, A2, A3 because I might end up putting 500,000 pieces of paper in that case, and if I just do it 1 through 5, you know, or 1 through 10, then I run out of room. You know, if I do it A1, A2, A3, then I can go as far as they can count and then go B1, B2, B3, you know. So I always do it that way. Enter exhibits as A1, A2, A3 like that so that I can always go to B2 or B3 and C3 and C4. And also you can set up your case in different ways to where they know A exhibits have this kind of information, B exhibits have that kind of information, you know. And you can't ever put enough exhibits to exonerate you, you know. Highlight out of your Texas Constitution, Article 1, Section 10, and highlight it and enter it as exhibit number 1, you know.
What was that again?
Article 1, Section 10. And then argue the fact of where's the separation of powers. They're in all violation. Yep, Article 2, Section 1 clearly states that 3 branches of government must stay distinct. Administrative, legislative, and executive, administrative, and judicial. And that in no way, shape, or form can those 3 intertwine or have an influence into the others. Yet, these corporations and the bar are creating legislation depriving us of our rights and then using judicial proceedings to enforce it. You know, well, that's in violation.
What you need to do on these, when you go in there on the code or whatever, tell them you want to see the enacting clauses enacted by the legislature and the enabling clause.
Yeah.
Where they got the authority on the Constitution to do it.
And the public law. See, like Title 26 of the Internal Revenue Code of the United States Code. Under the 50 titles listed under the United States Code, Title 26 is never been enacted as substantive public law. It is
See, there's
private
4
law.
things. For something to be a law, there's 4 things you have to have. It has to be enacted by the legislature. It's got to have the enabling clause. It's got to be authenticated by the Secretary of State, and it has to be published.
Right.
If any one of those 4 things are missing, it's a code or a regulation or a statute.
Right.
It's something else besides law.
Right.
They love to use law when they can. But that's
And
when
they
they
call
have
it
to put
law.
all these codes and regulations, all that kind of stuff in there.
Right.
Authenticated by who?
Secretary of State.
Uh,
And that's the point I was trying to make with the Title 26 of the United States Code. You look up in Bouvier's dictionary, and it says private law relates to private matters and does not relate to the general public at large. So if private law relates to private matters and does not pertain to the general public at large, then how are you trying to tell me that I am lawfully bound to obey Title 26? It has never been enacted as substantive public law. which means it's missing those 4 clauses.
One of the 4 things anyway.
Right. And that's a fact. It clearly states, right, next to each title, it'll say public law, blah, 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 blah. You know, public law, blah, blah, blah. Go to Title 26.
And what is that? Title 26.
Internal Revenue Code. And that's another thing. If you want to, people say, you know, I don't want the Social Security number. You know, it's the mark of the beast. You know, and people don't know why it's the mark of the beast. Well, other than the fact that they are giving it to you at birth now, and when it was first instituted, it was stated that you had to be of age because you were signing into contract to be able to get that Social Security number. Well, since the Emergency Act of 1935? No, 35.
33 before.
No, that's when they declared bankruptcy. But this
That's the Emergency Warfare
Act, Resolution Act of 1935, as amended 1939, Section 666,
No.
sets out the
No.
Social Security. Yes.
Section 666.
Section
Yeah, now that's
666.
new, though. Section 666 just went into effect in, what, about 99?
No.
It's new.
If you look it up, and I learned that from John Nelson, and it's in a seminar back from 1996 that he did in Dallas. He talks about it. The Emergency Resolution Act of 1935, as amended 1939, Section 666, gives forth the Social Security Amendment Act. So,
You know what we're missing though? All these groups, different groups fighting around here, telling all these tickets and taxes and all this. What they're doing is forcing us into one of their courts. We have to get our county court back where the county judge resides.
right?
Get state constitution, you can read Article 5, Sections 16, 17, and 18. You can go over, 15, 16, and 17. You can go over and read Section 29. You'll see. The only place where our power is in the county itself. It's in that county court where the county judge resides. He's elected by the people. That's the only court we're supposed to go into. And it has to be an injured party when we go in. It has to be a court elect act.
Right.
Or there's no injured party, no case.
That's another argument that I have used that has worked in traffic is, in order to deprive me of life, liberty, or property, and my money is my property, there must be an injured party, a corpus delicti. A corpus delicti means an injured party. And I've argued that fact with the judge and said, where's the corpus delicti? The state is the plaintiff, I'm the defendant, and if the state has damages, I want to put the state on the stand, and if he ain't crippled and mangled and walking funny when he gets up there, or bleeding still, then there's obviously no injured party, and if there's no injured party, you can't have me here and deprive me of life, liberty, or property, which includes, but is not limiting to, my money. And your bottom line is I can get out of all this for money. If I pay for this, you'll dismiss it.
It's extortion.
Exactly.
You can do whatever you want to.
And when I told the judge that, I said, where's the injured party? And I don't want that officer coming up here. He ain't injured.
Yeah.
The officer is not a witness against you. Not in traffic court.
He's really executing the legislation they've created.
Exactly.
And him to go get anybody who does that.
And he's not
Bring him here and make
the
him
injured
money.
party. And the bottom line, to be guilty of any criminal offense, you must have a corpus delicti.
Like in a murder case, you have to have the body, habeas corpus.
Exactly.
Well, see, all murder cases has to be common law because they have to have an injured party.
Right.
You have to produce that body.
Yeah.
And it's the same way in the courts. You just got to make the judge realize that you know this. And tell him, listen, man, the state is filing suit against me. And if the state has injuries, I want the state on the stand so that I can look at them with my own eyes and know in my heart that I injured them. And if I can't cross-examine, that's another thing. You have the right as a defendant in any criminal defense to cross-examine the injured party. Well, if the injured party can't even be put on the stand because it's been a legislative incorporated municipality.
It's a bankrupt legal fiction.
Exactly. So you just tell them that. Bring forth the corpus delicti. Where's the injured party? Not the officer, that officer. And that's one of the arguments I used, in fact, to win that case where this whole thing with the suspended license started. When I was up there arguing with that, he was trying to bring these people up there as witnesses against me, and I said, I object. You know, this guy's wasting my time and the court's time. Those people's injuries are another time, another court, another matter. We're here today because of damages claimed by the state of Texas. And if the state of Texas can't put a witness up there as itself and say, I'm the state of Texas and this is how I'm injured, I can't walk anymore because he crashed into me, then they can't use them witnesses against you. Just argue that. Say, hey, their damages won't be heard today. That's another day and another court and another whole situation. We're here today to hear about the damages of the state.
The state will always claim that you violated the peace and dignity.
Well, show me
of
the state thing. Show me that
state.
piece of
Right.
dignity.
Yeah,
You
well,
gotta
what criminal offense is that to violate someone's peace and dignity?
Well,
And the answer is it isn't.
right.
Well, also, how can a bankrupt legal fiction have peace or dignity?
It doesn't.
See what you can do when you go in these courts, and then get up there. When they, even a municipal court, even if it's a city, in a municipal court, they'll say if they put Texas in, by the state of Texas,
Yeah.
then you can challenge that jurisdiction, tell them I'm here by special appearance. They don't know what you're talking about. You're challenging the jurisdiction of that court.
Right, and that's what that motion that you got tonight states. James D. Hardin, by restricted appearance, right off the bat, restricted, not willingly or voluntarily. You can always add that in there. I'm here by restricted appearance, not willingly or voluntarily, but under threat of arrest if I failed to do so.
Yeah.
So you can always say that also. But yeah, you're definitely always here by restricted appearance.
You always say special appearance, but restricted do the same thing.
Right. And invoke the common law jurisdiction. If you don't invoke common law jurisdiction, you're going to get railroaded in an administrative proceeding. So invoke the common law jurisdiction every time, because the common law is where your Constitution's at.
Well, you power.
Right.
But I wish everybody would read that about the county court. Next time you get the state constitution, read about the county court.
That's Article 5, Section 15, 16, 17, and 29.
Yep. 29 talks about the county commissioner, and it's very important. They're very important too. They play a major role in this thing. You don't hear much of them. They play a major role in this.
Well, the ones who are playing the biggest roles are the ones you never hear about.
Yeah, absolutely.
They don't like to come out in the open in the fresh air and sunshine. They like to hide in the back and send everybody,
Well,
some
they
law-abiding people like us against each other with guns and badges. Go do my will.
Right.
And get
That's how it's
people
been. Divide and
people
conquer.
Whose money
From the
is their
beginning.
God, to get people in the hallways of courtrooms and say, you go ahead and do that shit, or I'm going to go ahead and put you in a hole in the ground.
Yep.
James, would it be possible to take all of this fantastic information and put it together in the form of something like a workbook? Because all of us, I have a ticket.
Mm-hmm.
I got to know what to do.
Right.
And I know that, of course, it seems like every person's case is different. Had a little distraction back here, but still there are basic procedures that you need to follow.
Yes.
There's kind of a step 1 and a step 2, and there may be, on step 2, if your situation is this, you do this, or if it's this, you do that. But could it be put together in a workbook, instruction manual kind of a thing?
Before James answers, let me throw in a piece of information that you didn't mention. Her ticket was from the county sheriff, and she's due to appear in a JP court. And a JP court, according to statute anyway, is a court of proper jurisdiction, and it does lawfully exist, unlike the Houston courts.
Right.
And that is going to change how she has to plead it, because I don't think she can go in there and say the court doesn't have jurisdiction. Now, she might be able to demand a judicial hearing instead of an administrative.
She can demand a judicial hearing. She can still file a motion for common law trial by jury, and she can still file a motion for Article 3 court and judge. And you guys should have gotten copies of all these motions. The Article 3 court and judge, they're only sitting there while during good behavior. And if you can prove anything, in other words, give them judicial notice.
Right.
You know, are you aware that since we have been under the Emergency War Powers Act? It's the executive order, blah, blah, blah. And now, if he is aware by judicial notice that we are under Emergency War Powers Act and that the courts are to be closed during those times of war, then how could he possibly hold you in any type of criminal offense in that court? He's been judicially noticed now of a fact that has just changed the whole proceeding. And he's only
That's why they
there.
have a fringe flag, because they are military courts.
Yes, they are. But thanks to David Windbag Miller, as Standard calls him, Miller versus U.S., he brought all those arguments up and he lost, and now they use it as a case-site precedent against you. You know, so if you bring up the gold fringe flag argument, they'll say Miller versus U.S., no standing. You know, so keep that in mind too.
Tell you one thing I noticed about the flag, when I noticed one time on television when they had, whatever his name was, the railroad killer, that one of the appearances where they bring him in the court, I noticed there wasn't a gold fringe flag they had up there.
The Supreme Court doesn't have
it
a
was Supreme Court, it's district court.
You ever see, now that's
It's
because...
state district court, murder trial.
Let me
And,
answer that.
you know, I thought that, you know, that because of that, and it being murder, that they were going to do some type of common law trial.
Well, now, all murder
So
cases...
I went up to the, happened to be up at the courthouse one time, and I asked got to the clerk to get the indictment against him to see how they wrote his name, but they wrote the name in all caps.
Oh yeah, that's standard. They do that
Well,
every
that's
time.
standard. The code fringe flag is also pretty standard.
Yeah, you're
But
right.
see, all murder cases has to be tried in common law.
And if
All
you,
murder cases common law. Even O.J. Simpson thing is common law.
He was never indicted.
Huh?
O.J. Simpson was never indicted.
Well, anyway, it was common law court because of murder trial.
Whatever.
All
It
murder
was
trials
a
are
certain
common law.
one.
if you look up Title 4, Section 1 or 2 of the United States Code, it tells you the laws of the flag and tells you who's supposed to have gold fringe or a gold eagle and stuff like that. And only the executive branch is supposed to have any gold fringe on it. And the president's the only one that's supposed to have the eagle at the top of the gold fringe flag. And for instance, the FBI, they're not judicial. Every FBI agents are foreign agents. Their paychecks come from the IMF, bottom line. They're paid by the World Bank, and they're all foreign agents. And for that reason, they don't have authority here. So, you know, if you ever run into something with the FBI that's adverse to you and to your demise, take all the FBI cards you can get, boy, and send off for their foreign agent registration statements, and then file it in court that the punishment to this of under the Foreign Agent Registration Act for anyone representing a foreign power and not being registered as such, the penalty is 10 years imprisonment. And once you got all their cards, that's admitting that they've talked to you and that they're dealing with you. Same thing with the IRS.
about Department of Treasury?
Department of Treasury, that's a little different. It depends on who you're dealing with. The Secretary of the Treasury, Robert Rubin, he's absolutely a traitor, you know, and it's clearly admitted in Title 22 International Organizations, where they pronounce him to be their new governor, Secretary of Treasury.
When you talk about some of those, I think there's a number of things there's playing with words, and I think there's a Secretary of Treasury, Department of Treasury and the Treasury Department. I think they're two different things.
Yep.
And along the same lines, I think the state constitution brings up the assessor and collector of taxes.
Mm-hmm.
And I think that's a different office from the tax assessor collector, because why have the two different terms?
I'm not sure about that part.
But you read in there, it seemed like the description of the tax assessor collector is sort of a lesser office of some kind.
Huh.
And the assessor and collector of taxes is the one that's supposed to make the assessment of the taxes. Well, you don't ever get an assessment. You get sort of a bill, but
right.
there's no official signed assessment.
Exactly. Yeah, you're right. You
And
get a
all
bill.
different,
It's really a statement.
yeah, they call them, technically they're municipalities, but they're various agencies will send out different bills. You know, your hospital district taxes, your school district taxes, fire departments, police departments, all this. They administer different taxes, and of course, if you're paying on your house, you don't see it because, you know, it comes out through your mortgage. But it's all illegal because none of it goes to the assessor. You know, it just they just bill on their own. And I think that's one of the things that Kenny was fighting on, this tax thing he's got.
I gotta get back moving on that thing. It's going pretty good.
And I can
See what they
definitely
do,
tell
let
you.
me say one thing in Texas. Each state's different. But what they do on these property tax, when you get a notice of foreclosure, to win foreclosure, and you sell your house, somebody, probably working for the bank, will go down and buy that foreclosure. Say if you owe $10,000, they'll go down and pay those taxes. For you to get that house back, you have not only pay the $10,000, but you got to pay 25% interest.
Penalties. You're right.
Penalties, that's right.
Yep. That's why a lot of folks are starting to figure that out, and they're getting other people to go buy that out instead of doing it themselves.
Yeah.
They're saving tons of money doing it that way, and they're going around. They found a way to get around that little system there.
Yeah.
But
And
one thing,
the price varies in different states. Some states make 50%.
yeah, and some states don't have state tax, and some do. Like Nevada has a state tax, and Texas doesn't. Louisiana has state tax. Florida, you know. But one thing I can definitely say as far as IRS is do Freedom of Information Act requests. We did them, and they had me classified as a high-level drug dealer.
Yeah.
They had Mike Hawkins classified as a truck and chassis manufacturer. Mike was a underground coal miner, and Kenny O'Kane was classified as a truck and chassis manufacturer out of Puerto Rico. They had Leah, somebody else was using her social security number. She was classified as a resident of the Virgin Islands. And so, you know, you get your individual master files back and you mark them up objecting to everything, and then send them back and say, I want this information corrected, and you put it into your master file. And now they've been put on notice that their books and records are inaccurate. And so when you go to court, if and when they decide to bring you there, if they're dumb enough to, after you've done something like that, then you can show, look at all these things that they've got me wrongly classified as. And why? It's for a reason. They don't have rights to tax us, but they have rights to tax citizens of Puerto Rico and the Virgin Islands and Guam and
All their interviews.
right, and so forth. So definitely do Freedom of Information Act requests to the IRS and ask them for your IMF, individual master file. And if you own a business, get your BMF. It's a business master file. And it'll, depending on how long you've been paying and how much money you've made and paid and so forth, I mean, it could, you know, the papers that they open up like this, you know, they're all connected together and they flow back and forth like this. And we've seen files just so thick it's ridiculous. And by the time you go through there and you see all the different class codes and stuff, and we've got all the manuals in the library here that you can decode it yourself if you want. And, you know, 150 means this and 160 means that, you know. And to the average individual, or I should say living soul,
Person.
well, person is defined as a partnership, corporation, and so on and so forth. It's not ever class. It doesn't say anything about a living soul, you know, and that's why he brought up a good point with the person issue.
Yeah.
There have been others that have argued that also, the person issue, and have been successful with it. Some others haven't, but it's all in how you argue it and how much you know and how quick you come back when the judge says, yeah, you've been studying law. What kind of law? You know, that stuff they rule on in the courts, you know. If you don't come back with constitutional American jurisprudence, you know, then they're going to realize you are incompetent and unable to handle your own legal affairs real quick.
What
So-
does jurisprudence mean?
Amjur, it's the conscience of the law. If you look it up in the dictionary, in the Black's Law Dictionary, it says Amjur is the conscience of the law. So, I mean, the way I see that is what is your conscience? It is the being itself of the law. And something else to remember is anything that violates the law of nations is a violation of your rights. Because every country, you know, like for instance Hawaii, when we took over Hawaii and and put them under as part of territory of the United States, they had to redo their constitution because their constitution that they operated on for however many hundreds of years was not based upon the law of nations. And every constitution with every government that deals with each other, their foundation and their principles must be based off the law of nations. And that was pretty much our forefathers' Bible, if you will, you know, was the law of nations. So anyway, that's just a 2-hour in general brief of what's going on, and traffic is just a small part of it, and there's a lot bigger picture. And
But I tell you what, to get it back, we need to get control of our county court. And Robert Eccles resides down and go to him. That's where our powers are.
yeah, we need to start going to the courts, and we need to start filing motions and reclaiming. Well, you got to reclaim. They've taken away already, you know. You just got to be man enough to say, I'm the sovereign here, you're not.
Hey, don't forget about that case I told you about, that Manson versus Smith, 1829 case. Very interesting case.
Alrighty. Yes.
So, you just told us about a hearing that you had. I guess that was a hearing. That was not an arraignment, or was that supposed to be a trial and it got continued to
No,
January?
that was the arraignment. I was supposed to go down and make a plea.
You did all that stuff at the arraignment?
Yes.
Have to do it. You have to do it.
Okay.
Well, in the municipal court, it ain't gonna happen. You know, you go to the municipal court and you say, you know, give me a verified copy of the complaint. They're gonna say, well, until you make a plea, we can't give you that. The issuing citation is the complaint. And you say, well, I object. For the record, I object. But if you say so, and they'll say, you know, you have options. guilty, nolo contendere, or not guilty. You know, that's all we're going to hear today. That's all you're going to be able to say. Guilty, not guilty, or nolo contendere.
You can object to that.
And you can
because there are
object to that.
6 different pleas that you can enter.
Right.
That's only
And
3
you,
of them.
and you can tell them that too. And
What
say,
are the other 3?
well, you can, how about my right to plead insanity? That's another one, you know? And he's-
Non-substantive. is
Yeah.
another one.
and they tell you that you only have 3 options. You know, well, I object. You know, why are you trying to coerce me? You know, is this all to extort money from me? You're coercing me into believing I only have 3 options? When you know as well as I know that there are more options, there are 3 more other options, you know. How about insanity, or I can't pronounce that word you just said.
I can't either.
Non-substantive?
Yeah. And there's another one too, and I can't think of it right now.
Guilty.
Well, that was one option they give you, but so you object right off the bat, you know, because how can I make a plea? I haven't even seen a copy of the verified complaint. And you want me to make a plea based on that? You object to that and say,
That's
I
only a
want...
promise to appear.
Right,
That's all it is.
exactly.
Yeah, he tells you that when you sign it. This is not a plea,
Right.
it's just a...
Promise to appear.
Well, you
And-
can also say, I don't understand. So even if they do present something, you can say, I don't understand, I can't enter a plea for
And
something
he'll
I
say,
don't
well, I'm going to
understand."
enter a plea for you of not guilty. And in my case, I would say,
Said Jeffrey.
and I've told judges that I can't make a plea here. You know, you don't hold jurisdiction to hear me make a plea. And I understand that my refusal to make a plea will involve you entering a plea of not guilty for me, and I object to you entering a plea of not guilty for me on grounds of lack of jurisdiction to do so. And tell them, I want this on the record. You know, I object. For the record, I want it on the record.
I bet that freaks them right out.
Oh, yeah.
Yeah, something I've been thinking about, I haven't quite figured out how to work it up, a piece of paper to put in for them. If you look in the Code of Criminal Procedure, it says not guilty means that you're denying every aspect of the information or indictment. Well, look, there isn't one.
Right.
So I'm trying to work up some way to put something in front of them that if I plea or anyone enters
A plea for you.
into the court records not guilty, that implies the presence of information or indictment, and whoever would be doing such a thing would be creating false information in court records.
Falsifying
That's
government
what-
documents.
That's what's so
Submitting a false
important.
instrument for filing.
Right.
That's back in 20.
That's what he's doing. Because he's filing it.
Right.
He's not only is he generating it, creating the, uttering the instrument, he's also filing it.
Yes, he
He's
is.
handed it to that person right next to him.
But from
Put that in the record.
But
13
that's what's
cases in
important.
municipal court, I'm just telling you from personal experience. In the county criminal court, I got all this in.
They're not used to losing down at municipal. They think everybody just caves.
Right, and they're not going to allow you, and the only thing you can do is object to it and say, I want it in that record that I object to you entering a plea of not guilty for me,
See, that's
and
what's
then
so
go after them
important.
for fraud after the fact.
Now, how did you get in the county criminal court?
Because it's classified differently. It's a different classification. Driving on a suspended license is a higher criminal.
Class C.
Yeah, it's higher than a Class C.
Development opinion.
So now what's going to happen?
Now, wait just a minute. See, that's what's important about this complaint. The reason you always want a copy of this complaint, because you don't know what's on that complaint. You don't know what you're being charged with. You might think it's a little not wearing a seatbelt or whatever, but until you see that verified copy of that complaint, you don't know what you can't plead to something without your complaint and see what you're being charged with.
Well, actually, you really can't plead to a complaint because whoever complaining, it could be anybody. They
Right.
think there's something been done
Well,
wrong.
it's a county
That's
clerk
why it's
or
supposed
something.
to go to
Right.
the attorney, and he finds a specific law that
Right.
they believe has been violated, and that's what you plead to, is the indictment or information. But you really
Right.
can't do it to a complaint because
Right.
they vary so much.
Try this on for size. This case that I followed the motions in, they set it for trial and then changed it to hear motions, and I never made a plea. I have not yet made a plea. Remember I told you guys, I told them I can't enter a plea. They didn't enter a plea for me either.
So what is your
A
question?
plea has never been
I
in.
don't think these things in these lower courts like that, you're not supposed to enter a plea until the jury set. Or you waive right to jury.
Right.
Yeah, they just want your money.
Is there some kind of a flow chart?
God, they want your money.
There's some kind of a flow chart of how the proceedings are actually supposed to progress, you know, from that initial arraignment stage. You know, should they have not allowed a plea? I mean, that sounds right. If there's still motions to be heard, then not allowing a plea sounds correct.
Right. But the
Because the motion's clear as
standard
day.
and standard practice
Standard steamrolling cookie cutter
is
does
that you enter a plea
pay your money.
prior to going to trial. And no, you don't have to pay money. You know, you enter a plea. The first day you go to the municipal court, you can go pockets empty, don't matter. And no, don't get all excited and everything, because all that's going to happen that day is you're going to say guilty, not guilty, I object, you know, blah blah blah, and that's it. You're not going to be heard that day. You're not going to get to set a seat jury members that day. None of that's going to happen the first day in a regular standard traffic citation. The first day you go to court on that promise to appear is going to simply be to make a plea, and then after that they'll say, okay, this is your new court date and this is your case number, and they'll give you one of these, and then you know when your date is and what court you're going to be in now, especially in municipality, because they always change. You know, you might show up for the arraignment to make a plea in court 8, and then they set trial for court 3. You know, so filing motions into court 8 isn't going to help you. It's the wrong court. You know, so don't even go there till after you entered in that plea, and then you go in and you do your motions and you go file them with the clerk, and you've got to have 3 copies. One for the attorney's office, one for the judge, and a courtesy copy. And then you need a 4th copy so that in case they lose all 3 of those, you can say, hey man, look here, it was filed right here. See, I have my original receipt in district clerk's office, file stamped right here. You know, and if you don't have that to prove, then they'll say, well, we're not going to listen to any of these arguments because you don't have. You put it in writing, and I've had them do that to me at the municipal court.
The reason it's so important to get them file stamped is because the only thing that's file stamped is the only thing that you can use in court.
Yes.
It's like certified mail. If you don't mail it certified, they throw it out.
Right. And you got to be careful with that. We've learned that, especially with the IRS in court, we went to court and said, look here, man, here's my certified copies right here. Well, we sent them in to you. Right here, he received it. And they said, well, we'll bring him in. And he goes, oh yeah, I remember that. I signed for it and I never could figure it out why they sent me an empty envelope. There was nothing in it. See, that's how they'll get around your certified copies. So what you do is you send a letter saying, I certify under oath that I mailed these documents pertaining to James Hardin to the IRS district manager on said date, you know, and then you send it certified mail. Now you have a witness, you know. Hey, I know what was in there. I helped him put it in the envelope. That envelope was not empty. You see what I'm saying?
It's called proof of service.
Yeah.
I'll tell you another way you can do it too, because they charge you by the weight when you make it.
Yeah. How's that empty envelope weighing? Why did I get charged $8 for an empty envelope?
That's a real human day.
Okay, James, what's happening Wednesday?
Wednesday, I'm going to the municipal court, and it's set for trial for expired registration and vehicle inspection sticker
It's totally separate from what
from
we
this
just heard
county
about.
criminal, yes. And what I'm going to do on that day is say, look, here's certified documents from the state and from me showing that I faxed them this information and that they realized that they did get this at the state, and realized that somehow they lost it. And whenever they got copies of my certified mail receipts and stuff by fax, they immediately reinstated it. Now here's the letter from them saying that if I don't comply with these things, then they're suspending my license, registration, and vehicle inspection. Well, under those conditions, how could I have gotten it reinstated? How could I keep it up to date? You know, it was under suspension status, and now here they've admitted that it was an error of the state by evidence here. Here's what I faxed them, and the following day my license was reinstated. See what I'm saying?
Yeah.
And they're going to go, oh, okay, dismiss. You know?
This is not an arraignment.
No, this is supposed to be for trial for that.
So you've already had the arraignment on this thing?
Yes. And I pled not guilty.
Okay.
And so now I'll show up, and most likely, to tell you the truth, what's going to happen is, other than one time when we cleared out every jury member in the courthouse because they weren't members of or judges of my peer, they always take me into a side room every single time. They take you into a side room, and they're like, all right, you know, I'm offering you one more option, you know, you can do this or that, and we'll dismiss this, you know, and that's when I'll say, dude, look, here's my stuff right here from the state showing the state was in error, and by that error, I was bound to an impossibility. It's a maximum of law that no man is bound to an impossibility. So, since no man is bound to an impossibility, and the error was on the state's behalf, how are you going to hold me guilty and find me of something that was an impossibility, you know? And it was the error of the state. And he'll go, let me see that, and he'll look, and he'll go, oh, okay, dismiss.
So he'll dismiss this thing on Wednesday.
Oh, yeah.
And then
We won't set a jury.
And then what happens?
Well, then that's just one more case where I can show the harassment. I've been to court 14 times, and I've got 13 dismissals.
Okay, but then what's
For the same stuff. I mean, why are you harassing me? Why do you keep bringing me back in here for the same charges?
That's a separate case, though,
From the county
January
criminal.
22nd deal.
Yes.
So now, they are related.
Yes, except what happened is I had an officer that wrote me for the registration and stuff that day, who had character, as to where these other guys didn't. The day I got arrested, I wasn't even driving. They arrested me for driving, and what happened is we show up in her Mustang to get the motorcycle, because my international driving permit is covered for motorcycles too. And I show up there and because her brother-in-law didn't have a motorcycle's license, so they were going to tow the bike, and he was going to be stranded because he didn't have a motorcycle's license. So she calls me and goes, you got a motorcycle's license? I said, I got a motorcycle permit, yeah. And she goes, well, can you go get the motorcycle for us, you know? And give him a ride home. And I go, no problem. So we go over there, and I hand him my international driving permit and stuff, and he goes and looks up my name off of it, and comes back and arrests me for driving on a suspended license. And that's why I'm suing, because I never got on the motorcycle.
Now, that motorcycle incident, that was where they discovered that you had the warrant for having the suspended
No
license.
warrant, no. I just had a suspended license. And so he arrested me for driving on a suspended license.
So he gave you 2 tickets at the same
Wow.
time.
There
One
was
for the
never-
suspended license. You weren't even driving.
There was never a warrant. You know,
Well, how'd
it's
you
just-
get there?
We pulled up in her Mustang.
Well, she drove you.
And then I get out to drive the motorcycle. And I never got on it. And he arrested me.
So he gave you a ticket for driving with a suspended license.
Right.
That sent you to county court where you just told us all about that.
Yes.
Okay. Was it that same traffic stop that brought you to this trial Wednesday?
No, it was the previous one.
Previous.
And what happened at that point in time, we were going down 43rd, and the officer sees my stickers were out, and he pulls me over, and I said, look, here, I got these paperworks, and I'm battling with the state trying to get this, right now, and I go to hand him the papers, and he goes, He goes, that's all right, man. And he just writes me a ticket for the stuff. He took my license, copied the license, information, my name, my address, and license number and stuff on the tickets, and wrote me for the registration stuff only. He didn't run my license to see that it was suspended. And that's why, and he was a very nice guy. He comes back, says, I need you to sign this, what it's for, just be at the court on this date. He goes, you'll probably have it taken care of by then, you be safe. And he goes, and by the way, I noticed you ain't got your seatbelts on, y'all should buckle up for safety. Totally how a peace officer should act,
Yeah.
And then today, I get pulled over by a stormtrooper, and he's in front of me, and I'm behind him. My stickers are all good and everything now, and he pulls to the side of the road. I pass him, and he gets behind me and pulls me over, and says he pulled me over because I don't have a license plate on the front of my truck. I got a Jesus is Lord plate instead there, and gives me says he's writing me tickets for no front license plate and for not wearing my seatbelt. I'm like, okay. So he asked me for my license and registration and proof of insurance, and I give it all to him. He goes back to his car, comes back and goes, you don't have a valid license. I go, yes, I do, man. I'm like, God, dude, they're going to try and take me to jail again, man. I'm all shaking and everything, I'm like, I got to go through this again, man. Handcuff cuts and everything else, And poor circulation. My thumb still goes numb on me and stuff from being in handcuffs for 2 hours over that incident. And so my heart's racing and everything, And I said, here's the paperwork right here. I don't want to see that paperwork. I said, it's from the state. He goes, I am the state.
Yeah.
And I'm like, dude, I'm just trying to show you right here. It says to all public officials, it could take up to 10 days, and that I have complied with all these transportation codes, and it has all my stuff has been reinstated. And I go, so why are you giving me a ticket, And he goes, well, I'm just going to give you a warning on that plate, but I'm writing you for no valid Texas driver's license and for the seat belt, and then gives me a warning that my back plate is the view is obstructed by the balls for the trailer. It's like, why do you sell me a truck with only one spot to put the trailer ball and then give me a ticket for it? Again, bounding me to an impossibility. Show me a one dealership that sells pickups where the ball don't go there.
Yeah. Right.
And so anyway, I go, well, so you're going to write me a ticket for no seatbelt? And he goes, yep. And I go, what law says I have to wear a seatbelt? And he goes, Texas law! Like that, and hits his hand on my door and hits me right here, man. So I went down, filed a complaint against him today with the Harris County Sheriff's Department for assault, harassment, and threat of arrest, because not only did he assault me and harass me, but he writes me the first ticket at 9:45, and that's this one. At 9:45, he writes me a ticket for failure to display valid driver's license and ride not secured driver, no seatbelt. And then warnings me for no front license plate and obscured rear license plate. I mean, the dude's just totally harassing me, right? And then after doing all this, I'm pretty shook up, and I sign it. So I sign it under duress, because of the way he's acting to me. And he hollers over at his partner, sign it under duress, eh? And I'm like, man, I just want to get out of here, So I take off, and I'm half a mile up the road, and he pulls right up on me, tailgating me, man, for about 2 minutes.
You should have hit your brakes.
Yeah. That would have been great. And he pulls me over again. He pulls me over again and writes me a second citation at 10 a.m. for ride not secured driver, and threatened to arrest me if I didn't put my seatbelt on. So,
Well, he must have a warrant then, if he's gonna arrest you, got to have a warrant.
Right.
well, not only that, but no man can be tried twice for the same offense, much less in the same 15-minute period by the same cop on the same road. You know?
Yeah.
What's up with that? I mean,
He's exactly the kind of weak mind that I was talking about before. They have to hire people that are like him to have the
bully
whatever,
mentality.
yeah, to have the arm, the push around power,
Strong arm
to make
tactics.
people you will obey.
Yeah. Texas law!
Texas law!
That's what he told me, just like that.
He's a weak mind. He's probably, money is this guy's god.
Well,
You
put
should've
him
told
on
him.
the stand and he'd be the same as James was, if he wouldn't know where it showed me in Texas law.
Right.
Where is that?
Yeah.
He'd be
Oh, yes.
stuck.
Well, he's just-
I saw a trial recently in Galveston County where they had the cop up there, and basically, the guy, first he brought the transportation code and other things that he had, and the prosecutor objected, really just because he hadn't described it into the record what it was. He was trying to get into evidence.
So used
So he put back down and he looked on the prosecutor's desk. Well, he used this one. It's got something wrong about it. It describes it a little bit. And he objected to that, and the judge said, "Well, let me look at it." Well, he thought this was okay, and then he gives it to the cop to look up the law that he was attempting to enforce on him.
Right, and he couldn't show
And then
him.
he just stayed quiet. And after about 10 to 15 minutes, I think the judge was getting embarrassed. He had the jury take a break, and they went off, and he'd look up at the prosecutor every now and then,
Like,
how do I do? Help
what
me.
page, right? Where do I go? They don't
They're out for a
know.
while, they come back in. He still hadn't found it, and
Well, they're taught procedures. They're not taught the law.
See, they're violating their oath, too. Every time they do
Yeah.
that, they're violating their oath.
Absolutely. They swore an
they-
oath to uphold the Constitution.
So that means they know it. I'd a lot rather have one that has his oath than somebody who don't have their oath.
Right,
Because that means he's supposed to know what the Constitution says.
right. And so that's the whole idea.
You know?
If you get to trial, put the
Yeah.
officer on the stand every time.
And then
And ask him, how long have you been an officer? And have your paper and pad ready, 10 years, all right. You always been in traffic? Yeah? Oh, just the last 6 years? Okay. Well, how many tickets do you think you write a week, roughly? 100? Wow, and the average price for speeding is $100 fine? 100 times 100, that's $1,000? Man, that's a lot of money.
10,000.
10,000, right, 10,000. And so, you just do things like that, and the jury sees right through it at the end, and then tell them, for speeding, have you ever seen this document, and hand him a copy of it? Can you read that to me? Oh, and he reads it off. Speed limit signs must be posted every so many feet on the highways with the maximum rate of speed for commercial vehicles, semi-tractor trailers, tractors, omnibuses, and other vehicles of commercial purposes. For hire. And
That's the way the law reads?
absolutely. So those are not there for us. Those are speed signs for commercial
the
vehicles.
real thing of that particular section of
I think
transportation
it's
code,
on the
in
board right there.
paperback books that most people get, it's missing. It's in the hardbound volumes, it's in the libraries.
Yeah. Well, we got it off the internet
Yeah,
one night.
it's on the
Transportation
webpage,
code.
yeah.
Yeah. And we downloaded it, and that's what I took into court with me. And I told him, I said, I want to enter this in as an exhibit. And he goes, that's not a timely filing. You can't do that. And I said, hey, the proceedings haven't started. I've already filed motions 3 weeks ago, and I just want to add this one piece of paper in as an exhibit to my filing. And then, boy, he snapped. Oh, you think you know it all? And then he takes me in the back room and he dismisses it. Because that's the way it reads. It only applies to commercial vehicles, and it doesn't apply to private. Right.
What do you think the next move is going to be? I mean, as people become more knowledgeable in their own self-defense, Americans typically are at their best when things are at their worst. So as we become more responsive as a society to this, Do you see them, I mean, I know they're
Well,
already
it's
attacking.
happening right
They're
now.
already attacking the Constitution.
Knowledge is, knowledge is.
What do you see there, you know, what are your thoughts on their responses to protect their little kids?
I'll use an example that was said in the IRS case.
And start doing what.
The guy says, I do not volunteer to their voluntary taxing authority. And the judge looks at the prosecuting attorney and says, it is voluntary system and he don't volunteer, so, you know, how do you enforce voluntary compliance? And she says, by scaring the heck out of them. They will keep using strong arm tactics to scare you, you know, and sending their big old cops in your face and screaming at you, Texas law! Right, and using those tactics to scare the heck out of you to enforce them.
Which will just rouse more of us.
You're right, but however, there will be more that back down than will stand.
Well,
And if the majority
pendulum swings.
of them back down, then their system is working for them. You see what I'm saying?
Yeah, on a percentage-wise, yeah.
That's the reason.
Yeah.
I mean, I've been to court, and who's lost really? Me. They've dismissed my cases, but I've lost time, work,
Well,
time.
See, the problem is though that,
you don't get it.
the problem is that they're never really satisfied. You know, for these people, you know, you gotta remember, money is their God. So for them, the thought of you keeping that $100, here's people with millions of dollars. The thought of James Hardin keeping that $100, it just gnaws at them in their sleep. They gotta have it.
Yeah.
So they've gotta step out of the realm of the appearance of propriety. Eventually.
Well, I've had them literally screaming at the DA, telling him, get him out of my courtroom! Get him out of my courtroom! I don't ever want him in here again! Get him out! Literally. I mean, because I was bringing up facts that he didn't want that court to hear.
It unveils to him the truth of the matter.
Yep.
That's their, you know, whatever.
On those
Regardless
motions,
to the
is my,
vampires.
right? On the motions is my phone number. If you guys want to contact me or anything, you got questions or something like that, all the motions you got today are already in the computer. You can come to this computer anytime that the doors are open and
If you want to
just
come late
modify
tonight,
them.
you just call ahead, I'll wait for you. I live right around the corner, I can come here.
Just
Be here
emailing them
in
out.
10 minutes or... Wait,
Yeah, I can do that too.
what was that? I'm Mike Murphy, I work here.
Okay, Mike.
You're Mike Murphy?
Yeah.
I thought that guy was named Mike Murphy.
No.
Danny Murphy.
Oh,
We got two Murphys.
So, what was the proposal just made?
If everybody wants to give me their emails, I can email you in Microsoft Word, and
Just call the office. I'm
you
here all
can
day.
have the complaints already done and just modify them to fit your needs.
973.
I'll send it as an attachment.
422. Full access.
See, one
Excellent
thing
job.
about a municipal judge and
Good job. Thank you, sir.
Enjoy it.